What the court was really doing, in my view, and this is kind of the point that we're making in the appeals, is disagreeing with the wisdom of the law by refusing to enforce it and refusing to provide a mechanism to enforce it.
Before we get to the interview, I just wanted to give you an update because there's a lot of breaking news going on, which had not happened at the time we recorded the interview. And please stay tuned after this breaking news to hear the interview with Will Lowrey and Jessica Blome, which is terrific. But you may have heard this news. There have been two big breaking stories with legal issues involving direct action everywhere. One really bad, one mixed, but basically good. I'll start with the really bad one. Zoe Rosenberg has been convicted of conspiracy and trespassing for her rescue of 4 chickens. And you're probably familiar with this case. You probably heard our interview with Zoe. But we really had high hopes. She was really well represented, and of course, the court made some terrible rulings, not allowing her to bring her primary defense, which is pretty disastrous. And of course, there will be an appeal. But my heart is breaking. I mean, it's just to be living in a world where Donald Trump is president and Zoe Rosenberg might go to prison for rescuing unbelievably abused chickens is just what can I say? There'll be more news about this upcoming, but I just wanted to give you a heads up. The other piece of news, which is actually not perfect, but is good news, is that you may have heard, you might be familiar with the investigation by DXC of Ridgeland Farm. I think it's called Ridgeland Farms. It's this dog breeding facility and research facility in Wisconsin. Their main business is breeding dogs and selling them. Beagles, of course, because they use beagles in research, and they also do some research on their own. There was a huge investigation, and there was going to be a prosecution. And I think I interviewed Wayne and other defendants or lawyers about this back at the point where they were about to be prosecuted. Then immediately after that, in this just inexplicable development, the district attorney in Wisconsin dropped the charges. Yeah, to drop the charges of a very complex case right before trial is bizarre. They claimed it was because there were death threats, which was ridiculous, but that's the kind of thing they say. All right, so then the tables totally got turned. DXC and its lawyers brought an action in Wisconsin and got a special prosecutor appointed, got a great decision from a judge to investigate what was going on at Ridgeland, which is clearly against the law. It's, everything these places do is completely against the law. Just nobody cares about it. And that they've been stalling that for a while, and there was clearly a deal that was done. They're not going to be convicted or plead guilty of any crimes, but they are going out of the breeding business. I think they're still going to be able to breed dogs for their own research projects, which is very sad. And this isn't going to go into effect for 8 months, so there will be much suffering before it ends. But all in all, this is, in animal rights terms, this is a huge legal victory. So congratulations to those folks. And we'll be talking more about these cases in the future, but I just wanted to give you this heads up in case you hadn't heard.
Welcome to the Animal Law Podcast. I am so pleased to have 2 people back who have been on before to talk about this case, Animal Partisan versus Superior Court of Monterey County. And it's just one more case that you start reading it, you're like, oh, and then by the time you finish reading it, you're like, oh my God, what is going on here? And establishing that when it comes to farmed animals, statutes frequently don't mean what they seem to mean. And first, before we get to that, please remember to subscribe and hit like on your YouTube or wherever you are listening. And now we're going to get to my guest. Will Lowrey is the founder and legal counsel for Animal Partisan, a legal advocacy organization focused on challenging unlawful conduct in animal agriculture and experimentation. And he also currently teaches animal law at the University of Oklahoma College of Law, which I did not know. Jessica Blome is an animal, environmental, open government, and land use attorney at Greenfire Law with nearly 2 decades of experience in complex litigation. Welcome back to you both. It's such a pleasure to have you here.
Thanks for having us.
Yeah, thank you. One thing I should have asked you before I started, but I didn't. I don't really know which of you is responsible for what parts of this case. So I'm just going to throw it out there, and whoever wants to answer, please do. And then maybe the other one can add something, but I won't ask you questions specifically most of the time, except like, let's start with Will, just to give us the beginning of this case. Tell us about is it the Shock family farmstead?
Absolutely. So, this is a dairy in California, and so this is not the biggest dairy in the world, but it is a dairy in California. And we have been looking for some fact patterns in California to try to use a law, and the law specific to this case is California Penal Code 599A. And so, to your question, we came across this dairy, and we believed that some of the conduct committed at the dairy, specifically the confinement of dairy calves, violated the law, and that was the impetus of the case. We did an investigation, got some photos, and it kind of went from there. But to your question, yes, it's a dairy in kind of central California.
Yeah, and I obviously want to get to the details of 599A in a moment. But first, can we just have a little background? I know that Alexandra Paul, who has been on the podcast, was involved, and there was an investigation. How did you find out about it, and how did you pick it? And can you just kind of walk us through what she found?
Absolutely. I think I'd start with the basis that the conduct that was witnessed here was visible from the roadside. And I'm not from California, Jessica is, and feel free to chime in. But if you drive around California, it's not difficult to find agricultural operations. And so you're right. Alexandra was involved in this case. She does a lot of activism and work in California. And ultimately identified from the roadside this specific farm, amongst others. This is certainly not the only one that's committing this conduct, but identified this farm and the housing in which the dairy calves were kept, which appeared to be a violation of another law, which we'll talk about. And so it wasn't identified through any magic or anything like that, other than just observing sort of typical California agricultural practices. And the conduct was witnessed from the roadside, photographed, and then specifically what was at issue was the housing in which dairy calves were kept. It was kind of these small wooden, green, sort of dilapidated looking hutches, and that the dairy calves were kept with no room for exercise. And then that led us to the legal case.
Yeah, can you go a little bit more specifically, like how I had been picturing when I read about this, these more typical little white, I guess, plastic hutches that you so frequently see dairy calves kept in. Sounds like these might have been about the same size, but maybe they looked a little different. And can you just talk a little bit about the size and how she knew there were actually calves in them? I have certainly seen these from roadsides in upstate New York as well.
Yeah. And so the size, I think in one of our complaints, we had, just as a matter of comparison, sort of an aerial image of the property comparing the crates to a pickup truck. And they were actually looking smaller than the pickup truck. So you're talking, 20, 30 square feet of space. And the hutches that you're referring to, most people have probably seen. They're kind of the plastic, people might have seen the igloo type dog houses. Imagine these for dairy calves, but larger. Well, this is about the same size, but constructed of a different material. I mean, here we're talking wood, sort of planks that are nailed together with a metal roof. And then to your question on how the cows were viewed, the pictures that we obtained show the cows basically through the slats in the wood. You can see either ears or a calf kind of peeking over, or you can see legs, and you can clearly see that many of these were occupied.
And I assume that during the time she watched, she didn't see the calves ever getting out or doing anything.
That's correct. And I think one key point, and this was a bit of an issue at the trial court, was that this wasn't just a quick drive-by, here's a picture, we have no idea what's going on. This was over the course of 3 days documenting this, sometimes for an hour at a time or more than an hour at a time. And to your question, Mariann, there was never any opportunity where the calves were let out and they romped around a pasture. In fact, there didn't even appear to be a fence where they could go out. They were confined to these specific dairy hutches. And also, it's in the complaint, but even during a phone call, someone at the farm represented that these calves stay in here for months at a time. So it wasn't just a tidbit of evidence. This was over 3 days, over many hours, plus a phone call. I think it's very evident that these calves are not being let out, not getting exercise.
So Probably a lot of people listening to this know about this kind of treatment of dairy calves, but you also do go through a lot of information in your complaint about why this is so bad. I mean, it may seem obvious that it's so bad, but can you kind of like summarize why this is so bad?
Sure. Yeah, we cited a lot of evidence, and it is not, hey, animal rights websites, people saying dairy calves should run around. There's a lot of scientific studies cited in our complaint that speak to the value of exercise for animals. How they walk when they're deprived of exercise, how it's a little more difficult for them to walk, the value of socialization, and all of these things speak to the benefits of not keeping dairy calves confined. I realize the dairy industry has its own reasons for why it says these animals should be confined, but there is a wealth of evidence out there that says, these are animals that they want to play and they want to socialize. And I think anyone who's ever been to a sanctuary or seen a dairy calf, I mean, we live where I'm sitting now next to 27 acres and our neighbor grazes cattle. And I look out my window all day and watch calves romping around on the fields. They're not just standing there saying, I wish I were confined to a 24 square foot space. They want to play, they want to socialize. And that's not just me saying that. There are, major agriculture universities. We've cited their studies and authorities in the complaint.
Yeah, did you also point out at all, or maybe it wasn't relevant to this particular lawsuit, but just the relationship between the mother cow and the calf? It always just seems such an act of cruelty to interrupt that. But I guess you were focused mostly on space here.
We were, yes, I agree wholeheartedly, but specific to our complaint, that wasn't a point that we referenced.
Yeah. All right, Jessica, maybe I said I wasn't going to ask you questions specifically, but now I am. Because you're a California attorney. I don't actually know whether you're admitted in California, Will, or not. But can you just give us, Jessica, can you just give us an overview of the welfare of how the welfare of farmed animals, or the lack of welfare of farmed animals, is governed in California, and then specifically go into this section 597T?
The farmed animals are protected in California from a welfare perspective more than most other states. We have a couple of really important propositions that were passed in past years, including Prop 12 most recently, which was an update that prohibits the confinement of animals without exercise, and in specifically veal calves. And so the 597T specifically states that, well, let me find it. Maybe Will knows this off the top of his head.
Sure. Yeah. 597T. I mean, the key provision here says every person who keeps an animal confined in an enclosed area shall provide it with an adequate exercise area, or with an adequate exercise area. So that for our purposes, it's important that the animals are confined. And if they are confined, they shall be provided with an adequate exercise area. That's the important part.
Yeah, Jessica and I were talking before you joined us, Will, and just talking about how interesting it is that, I mean, this is an old statute, I believe, like maybe 100 years old or so, and they understood at that time that it would have been cruel to keep an animal without adequate exercise, and now that's all we do in the world. I don't know. That's not a question, really. It's just a commentary about how far we have fallen. All right, so this is a criminal statute, right? It's a misdemeanor.
Yes.
And of course, the statute that is actually at issue here isn't 597T, but I do want people listening to remember 597T is the one that provides that animals have to have an exercise area. And there is no exemption for farmed animals. There's no customary farming practice exemption in California. So there's no question, really, I think, that it applies. And it has pretty obviously been violated, I think, here. Though I guess you could litigate it. They could litigate it based on what adequate means. If, absolutely no exercise is adequate, you could make that argument. Clearly, they don't want to make that argument. But this case, as is almost always the case, involves not whether the law has been violated, but who can do anything about it. So now, can you tell us about the other statute, which sounds the same? It's 599A, but this is actually the procedural statute. So as we're talking about it, everyone listening, just remember that, because I kept getting them confused. Can you tell us what 599A provides?
Sure. Yeah. So 599A is what I would lump in as a sort of a private citizen complaint statute. And so you're right. We have 597T, which says adequate exercise area. But 599A, by the letter of the statute, allows a private citizen to go before a magistrate, which in California is a judge, and essentially seek a search warrant. If that person believes that any part of California's animal protection or cruelty laws are being violated, it gives the right to go before a magistrate and ask for a search warrant to go search that property. And so that's kind of what's at issue in this case is, does it give that right? We obviously think it does, but that's the point of contention here.
It is hard to imagine like what other how else you could interpret this statute, but that's where we are. So this is old, right? I said 100 years. Is it about that era?
Yeah, this statute was passed in 1905 as part of a much larger legislative packet of animal protection laws. And kind of to your earlier comment, Mariann, the legislature recognized that animals have value, they're important, and it wasn't just passing this random 599A. It was all of these animal protection laws, and included in that was this private citizens complaint mechanism to enforce them if needed.
Yeah, it's so interesting that even back then, Jessica and I were also talking about this, like even back then, they recognized that they were passing these laws, that they were important, but that they couldn't really rely on regular authorities. Maybe they thought it would be overloading the regular police and district attorneys. So they created like a number of like SPCAs, if they are given law enforcement power. They created these kind of unusual ways that private citizens could help out in law enforcement when it came to animals. And there must have been some recognition that otherwise it would be very, very difficult to get these laws enforced, which of course it is. Has this statute, do you know if the statute has ever been used? I mean, I guess you wouldn't necessarily know, because if it didn't end up in a reported case, you wouldn't know about it. But do you know of any instances in which it's actually been used?
I do not, and I've tried to find it, and I've had other people challenge me and say, surely it must have been used, but I've asked the groups that I believe would have used it, and the people, and I've not found anyone that is directly used it. And I think that's part of the issue that we ran into this case is maybe nobody's used it and nobody knows what it's supposed to do. So that's kind of why we're here.
Right. Or if it was used, it just ended right there. It was used, it was granted, they went and arrested somebody,
Right.
and it didn't become an issue. And there are similar statutes in other states, including New York, right?
New York and Idaho have statutes that are almost identical to this. There's other states that have the right to go in front of a magistrate. In Virginia, where I'm at, I've used that statute. I've gone in front of a magistrate in North Carolina. So this is not some random anomaly that only exists in California.
It's so interesting when you think back, like there must have been like some kind of law reform effort that some people were working on to kind of create this body of statutes, and they sent it out to different states, and some states adopted some of them. I don't know the history, but I think it's really interesting. All right, so you have the evidence, you have a statute, and as far as I can figure out from the papers, you have what is probably the most important thing for any lawyer, like some kind of guidance of what the papers are supposed to look like, where you're supposed to file them, well, it does say magistrate, which you tell me means any judge in California. So that's helpful. So tell us that story. What papers did you prepare? And then what did you do with them?
Yeah, well, that was a hard question to answer. Will, you should probably tell them what you attempted to do, but fundamentally what happened was Will called the clerk's office at the Monterey County Superior Court and asked them what it would take for him to file this type of complaint with the Monterey County Superior Court in order to get the issue before a magistrate capable or qualified to issue search warrants.
Can I just add something first, just because I just don't know? So the Monterey County Superior Court, does that have both a criminal part and a civil part?
It does, yes, and that
Okay.
became an issue.
Yeah.
In California, the judges are really siloed into their different departments. And so in order to get something before a judge capable or qualified or empowered to issue a criminal search warrant, you need to be in the criminal court. So the clerk of court responded and said, no one can request a search warrant except for law enforcement or the district attorney. And so there's no process for you, Will Lowrey of Animal Partisan, to present this information to the court. Will responded by giving the clerk the case law that supports the use of 599A in this way, and that stems from two cases brought by the Animal Legal Defense Fund over the years trying to enforce 597T through civil courts. And in every instance of the Animal Legal Defense Fund's efforts, first using the Unfair Competition Code and later trying a taxpayer waste claim, the courts have said you can't use the civil code to enforce a criminal law. You must use 599A or a different provision that allows an SPCA to enforce the criminal code. So
and
even
in those cases, the court specifically referred to 599A?
Yes, yeah, the court
Wow.
specifically incorporated the language of 599A and said this is clearly and
This is what you
explicitly
do.
an option for a person. So upon hearing that, the clerk said, and this is a very typical thing that the clerks say to us, not just animal lawyers, but all practicing lawyers in California, when they've hit any kind of roadblock or adversity or pushback, they say, well, I'm not allowed to give you legal advice. So that the conversation ends here.
Even though they basically just had. And
Even though they basically just had, and even though they were wrong, and they just refused to listen to the rest of the story. So that's when Will decided he needed to find somebody to help him with the civil proceedings. So what we did was we just filed we prepared at first just the request for search warrant with on a document that looks like a civil complaint, but we titled it request for search warrant. And in the two affidavits, one from Will and one from Alexandra, documenting the violations. The court rejected that filing, saying that they couldn't in civil court accept anything called a request for a search warrant. So now we're in a circular civil procedure quandary. So we decided to just file it as a complaint with an attached request for search warrant and a proposed search warrant. And this put us in a tricky procedural posture because a civil complaint is a lawsuit against a defendant. And in California, there's really strong protections for something called a real party in interest. So we were supposed to serve Shock Family Farms, but serving Shock Family Farms with this packet of papers would certainly defeat any efficacy of a search warrant. So we felt a little bit stuck, but that's what we did. And then we decided just not to serve Shock Family Farms.
All right. I'm already like, oh my God. I mean, just I so admire your patience in this case. Because I mean, as any lawyer knows, like the way you prepare papers is you copy other papers. Like that's what you do. That's what you're supposed to do. It's not cheating. And here you had to make it all up yourselves, like what these papers are supposed to look like, what court you're supposed to be in. So there came a point where you did get before a judge. And though that took a little time, and also you had gathered some additional evidence, is that right?
We had, I think you're speaking to the multiple days that we had gone to the farm. And so at the point we went to the judge, we had 3 days worth of photographs plus the phone call. And so, there were several months that had passed after the last photographs, mainly because we were trying to figure out how to get into court, but we eventually did get before a judge.
Right. So that's when the story really gets interesting. Before you got before the judge, though, you got what was called a tentative ruling. Is that a normal thing? Or like, is that common?
Yeah. So there's a couple of points. I mean, I think in Monterey County and in counties across California, courts are really booked up, especially ever since the pandemic. So it's hard to get a hearing. So I just want to point out this one little additional oddity and also, potential issue that we ran into, which was the case would be automatically dismissed for failure to prosecute if we didn't serve Shock Family Farms by the 60th day. And the Monterey County Superior Court was also telling us that we couldn't have a hearing on our request for search warrant. So what we did is we moved for admission of Will pro hoc vice and then requested a hearing on his motion for admission pro hoc vice, and then told the court that we would piggyback our request for search warrant off that hearing so we could get the reservation. So we had to do this crazy procedural thing in order to even get the hearing before the judge, which took place on the 60th day. So
Wow.
There was no way we were going to be able to serve Shock Family Farms. And this ended up being a concern of the judges that Shock Family Farms hadn't been served. And because they hadn't been served and the hearing was on the 60th day, there was no way to serve them on the 61st day and still maintain the lawsuit. So it was really a ride or die hearing. we were going to get this search warrant or we were going to be done in civil court.
And I mean, I have some sympathy for the judge in the sense that it must have been like, what the hell? But on the other hand, I don't have a lot of sympathy because she was not very interested in figuring it all out. All
Yes,
right,
and Will handled that hearing, and he did a masterful job.
I'm sure Will is like the soul of patience, I have to
Yes.
say. So the first, I don't know whether this was the first thing that came up, but one of the big things that came up is that the court, kind of understandably at first, thought you were trying to file a civil lawsuit. I mean, here you were in civil part, and you file it. So at this point, can we just take a moment out from the timeline to talk about Mendez and because she thought you were doing what Mendez had told you you couldn't do. And this other case, I forget the name of the case, but there's two cases that say you can't file a civil lawsuit for violation of this statute. And that you had to explain to her that you were trying to do something different. Can you just explain that interaction?
Sure. Yeah. So there's two cases, and credit to Animal Legal Defense Fund. The first one is ALDF versus Mendez, and this is a 2008 case. And ALDF was also trying to enforce 597T, so the law that requires an adequate exercise area. But part of that complaint was trying to argue that there was a implied right of action in 597T. So they weren't going through 599A, what we were using. They were saying, you know what, inherent to 597T is a civil right of action that allows us to bring this case. And the court in Mendez said, no, you can't do that. There's no civil right of action. But you know what? There's these other things, including 599A. And so Mendez is very important. And when we got before the court, we spent quite a bit of time sort of arguing about Mendez, and credit to the judge in the Superior Court who let me go on and on for about a half an hour. And we talked about Mendez quite a bit. And I think at one point the judge said something to the effect of Mendez can be read in many different ways, which I obviously disagree with, because to me, Mendez is pretty clear that 599A is a legitimate path. But I think there was some confusion about what we were trying to do, and the judge may have thought that we were trying to do the same thing ALDF did and enforce 597T through an implied right of action, which was absolutely not what we were doing. And so we just kind of butted heads about the meaning of Mendez, and the judge viewed it differently, and that was part of the reason that the search warrant motion was denied.
And I did see in your papers this statement from the court that said, I read it differently, or it should be read differently. Was there any explanation as to how it should be read? Because it really is hard to imagine how it could be read differently.
There wasn't, to my recollection, any further elaboration on that. It sort of all just led to this, as Jessica said, you need to go through a prosecutor and law enforcement, right? I can't imagine why a private citizen could do this. The floodgates are going to open. And from my perspective, I'm looking at 599A, and it plainly says we can do this. Mendez says we can do it. There's another case in 2015, ALDF versus Cal Exposition, that endorses Mendez, says we can do it. So, Mariann, to your question, there was no real elaboration on what the different meaning or reading of Mendez was, other than you can't do it. You need to go to a prosecutor or law enforcement.
Yeah, I figured that since it wasn't in the papers, but I just was really curious. Like, to say this statute could be read differently and not explain what that difference is very frustrating, especially when it's really hard to imagine how it could be read differently. All right, so does that cover everything that came up at the hearing? Should we get on to what the court ruled?
Well, real quickly, I wanted to explain the tentative part. You had asked about that before, and it is normal in California for judges to issue tentative rulings. The California Rules of Civil Procedure require that you adopt a tentative ruling procedure. So we found out the judge's decision the day before the hearing at 3:00 p.m. And then we had to tell the judge we were going to contest the ruling. And her decision in the tentative was just a paragraph. And it was sort of a highlight, a preview of what her questions were going to be and what she was going to rule. But it ultimately was not exactly the same as what she ruled. So we can get into the ruling.
Yeah, I would like to get into the ruling because it had a few different aspects.
Yeah, I mean, so the tentative ruling touched on, you have no private right of action. It also mentioned the service issue that Jessica brought up. The final ruling, and it's short, so I'll just read it if that's okay, but the key passage says, quote, "The court does not find civil court is the proper channel for plaintiff to enforce California Penal Code 599A or the motion for search warrant. and the matter should be considered by the district attorney's office or law enforcement, end quote. And so it is, again, hinging basically the entire decision on the fact that the court doesn't believe that we have a right to do this, that all criminal channels need to go through the prosecutor and law enforcement. And that just, I think in our view contradicts 599A. It contradicts the case law. And that's why we decided to take it up to higher courts.
Yeah, and also the court found that, aside from the fact that it had to go through the district attorney, it found that civil court was not the proper channel, which seems actually correct. But you had asked her to refer it to criminal, haven't you?
Yeah, right at the end, and credit to Jessica for this. We had asked at a minimum, can you please transfer us to the criminal division of the Superior Court, and that was denied. And if I recall, the reason for denial was just it doesn't matter. You can't do this regardless of where you are. And so we asked and we tried. And to Jessica's point, it was in civil court because we had no other avenue. No one would tell us the way to bring this criminal action. This was the only way we could get before a judge, and we tried to get to the criminal division, but that did not work.
Yeah, no, it's great. It's like such a runaround.
It's an
really
absolute runaround.
classic. And to be clear, nobody ever reached the merits of whether there was a violation of 597T, right? Of course, it was all procedure. And the court said something about opening the floodgates. And I think the court had a very valid point there, because I think there's a very strong argument that virtually every animal-based farming enterprise in California is violating this law. It's really pretty crazy, the different like the contrast between what this law says and what is happening. So do you think that the floodgates problem, if people brought frivolous complaints, that wouldn't be a floodgates problem? You can just toss them if they weren't supported by evidence. The real problem here is that this is being violated all over the place, right? Unless they want to come in and argue that, what was the phrase in it, appropriate amount of space or something like that?
Adequate.
You could litigate that. They don't want to do that, do they?
I wouldn't think so. I would think that that's not an issue. To your question about the floodgates, the law's been around for 120 years and the floodgates haven't been opened yet. And the court, theoretically, as the law is written, should be a control. People aren't just going to run out and get criminal charges on anyone. You have to go before a magistrate and display probable cause. And so it's not like suddenly everyone is in violation and animal agriculture will collapse and crumble. We're just asking for a procedure that exists. We just want the opportunity to be heard, to make the argument that the law was violated. And the court is, in theory, the gatekeeper. But unfortunately, we couldn't even get that argument out. We couldn't get to the merits.
And clearly, if there was some finding that any kind of intensive confinement was in violation of California law, the legislature could just hop on it and fix that. It's just that they don't want to. It seems like they just don't want to have to deal with it, and they don't want it public.
I think that's the key point, that the length of the law being in effect indicates an endorsement by the legislature, to be sure, but it's also evidence that the legislature hasn't done anything to close a floodgate that they perceive. And so what the court was really doing, in my view, and this is kind of the point that we're making in the appeals, is disagreeing with the wisdom of the law. By refusing to enforce it and refusing to provide a mechanism to enforce it, they were nullifying a publicly enacted legislative provision without any input from the legislature at all, just deciding not to use it.
I was just going to elaborate on Jessica's point. And we made this point to the court, in that the 599A has been amended twice since passage, I think in the 50s and then in the 90s. And so there's two times where the legislature could have said, you know what, this is a mistake. We want to reel it back in. And they didn't. Those changes that were made were like form and format, nothing related to substance. And I think that just supports the argument that it is the intent of the legislature that this law exists. It's had ample opportunity to change it, and it did not.
And that goes to 597T as well. That's not been, it's not been significantly altered or removed from the legislative code, nor has there been a farmed animal exemption inserted into it. These laws exist and they're just not being enforced.
Yeah, I don't know whether there's any other state, you probably know this, that has a law like that. It's one that I'm not familiar with at all. But it is just this extraordinary situation that California has a criminal law
making what virtually every factory farm and virtually every farm in the state in violation of the law. And they don't even try to fix it. They don't even try to say, oh, that law was stupid. Animals don't need exercise. I mean, they just let it continue. All right, I'm going on. Tell us about the appeal. It wasn't actually an appeal, right? It was though California procedure is just very oblique to me. But it was a writ, a writ of mandate. Is that like a kind of jurisdictional complaint, as it would be in New York, or did you not have an appealable order? Is that why you didn't bring a straight appeal, or am I just not understanding California procedure?
We did have an appealable order because the judge dismissed the appeal. So we have two choices, and we still have one open to us, which is the actual appeal. That appeal, the notice of appeal is due in November sometime. But first, in order to get a judge to fulfill a mandate, you can file a request for a writ of mandate to the Court of Appeals, asking the Court of Appeals to review the issue and mandate that the judge take a different choice. But the choice has to be a mandatory choice, not a discretionary choice. Here, we felt like the choice was mandatory, that they consider the request on its merits. And so what we asked the Court of Appeals first was to issue a writ telling the court that they had to consider our request for a search warrant pursuant to 599A. At that point, their discretion would kick in. Whatever magistrate judge caught the case would be able to say yes or no based on the facts as presented. But we just were trying to get past that initial hurdle that we believed 599A provided a clear mandatory duty or mandatory benefit to us based on a mandatory duty owed to the public by the court.
So assuming, I mean, so far your appeal, which is on this very narrow issue, is not an appeal. Your application for a writ has not been successful. Are you saying that if it were successful, that or if it continues to not be successful, I'm sorry, I misspoke, that you would then be able to bring a straight appeal?
Yes. Yeah, we would. So the next step, the Court of Appeals denied the writ without explanation in a summary decision. And then we have appealed that or requested reconsideration by the Supreme Court of California. Again, just asking for that procedural question to be answered. But we can appeal a straight appeal based on the decision, which was a final order dismissing the civil case. So we have an appeal option available to us where we could try and more fully brief and have the opportunity to respond, and then to whoever's going to defend the decision. Because that's another reason why we went the writ. There's no one on the other side to really defend the court's decision except the court. Again, shock family farms, who can't let them in. They can't know about this. It's been kind of tricky to navigate that.
Right. Yeah. And I mean, I worked at a court for many years, and I'll tell you, there's absolutely nothing that courts hate more than ex parte decisions, because you don't know what the other side's arguments are. Though here, it seems like it's hard to believe that Shock Family Farms was going to come up with anything really monumental. It's a pretty simple issue. It really is. There's a lot of procedural complications here, but the issue itself is just interpretation of a very clear statute, isn't it?
Well, Shock Family Farms isn't entitled to a defense in this posture. It's
please make that clear, because I'm not sure we did actually make that clear.
Yeah, we're requesting a search warrant. So what we're asking the court to decide is that there's probable cause to exist for the further investigation of this entity to determine whether there was a crime committed, and then ultimately eventual prosecution. But there's a lot of discretionary steps along the way. And the DA or law enforcement or sheriff's office or whoever would catch this search warrant and be required to execute it would need to do it in a way that would surprise Shock Family Farms in order to be able to gather the evidence necessary to substantiate the crime. Investigations must be conducted confidentially. Otherwise, they're not much of an investigation at all, because the other side can destroy evidence or change course or do something in order to thwart the criminal action.
And anyway, there's just no reason they would be entitled to it. I would set a precedent that anytime you're getting a search warrant, the other party would have to be notified, which would be very silly indeed.
Yes.
So if this decision is correct, and if it is either upheld or you can't manage to get it reviewed, does that mean that 599A really has no meaning whatsoever? Because it doesn't seem to.
I don't think it says that. I mean, I think it will say that one, and I'd love to hear Jessica's opinion, but to me, it would say that one superior court has found that it's not valid, and that the two higher courts have said, you know what, we're not going to take this issue on, we're not going to address it. I think if the California Supreme Court decides not to grant our petition for review, to me, that just means they're not going to look at it. It doesn't mean they're going to look at 599A and say, this is invalid. And so, from my perspective, the law still exists. It's on the books, and I am kind of obstinate by nature. And so I'll try again. We'll bring another case in a different court and see what happens.
Well, actually, the key to getting this getting this reviewed seems to be to find a clerk's office that's a little bit more flexible in what they'll a criminal court clerk's office, because that's really where you got stuck, isn't it?
It was really that, the initial procedure. I mean, we were forced to go a route that probably wasn't a natural fit because we weren't given a procedure. So, yeah, I mean, I think if we were to find a court that said, you know what, this is how you should do this, we'll get it in the right channel, I think this probably would have been a very different case. And we probably would have had the motion for a search warrant heard on the merits, and we would have had to appeal.
Yeah.
I'd even go further and say that you could probably try this in Monterey County again. The decision that the judge issued is nothing. It's not published. It contains hardly any explanation or analysis. So if it would be dangerous in that we could get this judge again, but maybe we'd get a different judge and they might have a different view, or at least have that last thought in their head, which is what we requested at the end of the hearing, that the case be transferred to the criminal court. Maybe they would understand the procedures and process better and understand what we were asking for. Because it fundamentally seemed like our judge was having a hard time with the idea that Shock Family Farms wasn't there, that we didn't intend to serve them, that what we were asking for was a law enforcement activity. And she was a civil judge. She was really hung up on that. And, potentially correctly so. It's just we need someone to tell this court, and this is the beauty of the Court of Appeals, right? We were really optimistic about the Court of Appeals. We just need someone to say to the court, you have to do this. You can't ignore this provision like you're trying, like this circular, this guy, that it's this guy's job nonsense, and we can't give you legal advice, needs to stop.
Well, I mean, it's like Bleak House. I mean, this has been the most ridiculous, well, not quite like Bleak House. Hasn't gone on for like 30 years or something, but just crazy procedural morass. And I think that it's not totally disassociated from the fact that this is an animal law case, because people they're unfamiliar with them. They're not expecting them to be well litigated, and they don't want to end up in the papers. So a lot of heroic work hanging onto this case. We mentioned that New York and Idaho have identical statutes. Is there any case law in those states interpreting those statutes that make them clearer of what they apply to?
I would say New York more than Idaho. There's a few cases that briefly touch on it. Idaho, no. It's been a while since I've had anybody look into those, but there's not like a body of case law in some other state that would say, look, California, look at this other state. It's well defined. It's just not out there. And I think these are just underserved statutes. There's a lot of them out there that have utility if someone would just acknowledge them and say that this is an appropriate path. But there's not a huge body of case law out there in either of those states either.
Yeah, I think that sadly, 100 years ago when they passed these statutes, and they thought, well, we can't put all of this on the law enforcement authorities, but people will stand up to protect animals, and that didn't really work out. I think that they have not been used heavily, and given your experience, I can definitely understand why, because it turns out to be harder than one would imagine. All right, if there's nothing more on that case, Will, I would like you to tell us a little bit about some other matters that Animal Partisan is handling, in different stages, and perhaps in the future we'll be able to catch up with you on those.
Sure, yeah. Just one last point before we move on. I want to give a shout out to Jessica's paralegal, Donna Wallace, who did a ton of work on the Shock Family Farmstead case and helped translate a lot of complicated legal procedure. But Mariann, to your question, I would say another case worth mentioning, and I know you've long been interested, and I appreciate that. This is an Animal Outlook case that Animal Partisan is acting as attorney for Animal Outlook, but credit to them for the underlying investigation and all the work that went into this. I could talk about this for hours. I'll be very brief, but this is another dairy case. This is a dairy case in Pennsylvania.
Oh
It
my God,
stems.
not Martin Farms. Martin Farms?
It is
Oh my
Martin
God,
Farms.
I interviewed you about Martin Farms like, I don't know, 50 or 60 years ago.
Yeah, it was yes, I've been working on Martin Farms for 7 years now, and so the very quick update on that, and again, credit to Animal Outlook for a 2018 investigation at this Pennsylvania dairy that documented just horrific cruelty. That case also was a private complaint process. It started out as an attempt to get the district attorney to prosecute. The district attorney denied, ultimately went up to the Pennsylvania appellate court, who said, you know what, district attorney, you should prosecute. There's evidence. And it was sent back down. The short version, at the same time, the Pennsylvania Supreme Court decided another case that raised the standard of review for private complaints. And so that win that Animal Outlook had, some of it got undone. And they said, you know what? Your bar is now higher. If you want us to force the DA to prosecute, your bar is higher. So I think the quick relevant update here is that Animal Outlook case was back in front of the Pennsylvania appellate court. We argued that in early October. And so now the bar to force the DA to prosecute is you have to show bad faith, fraud, or unconstitutional conduct. So again, Animal Partisan's litigating this on behalf of Animal Outlook. We argued it in October. We argued the DA acted in bad faith. I think the real interesting part of that is that we argued that the denial was unconstitutional because it rested on the normal agricultural operations exemption, like the ag exemption to the cruelty law. And we argued that that violates the non-delegation doctrine. It's a long, convoluted argument, but we basically said that exemption is giving lawmaking power to the agriculture industry to define cruelty and neglect. And so that was argued in October, waiting on a decision. But again,
I love that argument. I love that argument. Those laws are ridiculous. I've always said that it's like if they passed a law saying that you can't throw pollution into the river in more than anybody else does.
Yeah, it's that's what it says. It says basically the law says if this conduct is normal in the agriculture business, then it's not cruelty or neglect. And our argument is that who defines what's normal? It's certainly not the General Assembly. It's the agriculture industry that's saying what's normal. Therefore, you're granting lawmaking power to the agriculture industry. That is a violation of the Constitution. And so that case is pending a decision. But again, based on some great investigative work by Animal Outlook way back in 2018.
Yeah, a long time ago, yeah. Well, I'm really looking forward to hearing what happens in that case. It's a really important case. And I really love that you come up with so many arguments that have to do with cruelty laws. They are the, again, I mean, as we've said, or as I've said, a few times today, back then when they passed all these laws, they thought they were going to do something. And I think they thought they were going to do a hell of a lot more than they do. And they thought that animals needed exercise. Unbelievable. So unless there's anything that you want to add, I really appreciate you both coming on. I know you're both extremely busy. And thanks for joining us. Thanks to all of you for listening. And thanks to Vicki Beechler, Jen Riley, and Akbar Khan for their help in producing this episode. Just a head up, this is our end of year fundraising opportunity, and our hen house has been operating for 15 years. Wow, feels like 50. We have this new podcast format, including YouTube. In total, we have released 862 consecutive episodes of the regular podcast and 125 episodes of the Animal Law podcast. And we have a triple match this year. So anything you donate between now and the end of the year will be matched not just once, but twice. So that's really exciting. This is when we raise most of the money for our entire year. So if you're not already a part of the flock, you can join us, or you can donate any amount of money during this period and it will be tripled. So if you're able and you value this, please visit our hen house. I know it's tough times for a lot of people. So we keep almost all of our resources free, but if you can chip in, we would really appreciate it.